So we're going to talk briefly about initial appearance, arraignment, and bond in the federal system. Most of it is you can just read the rules and it's relatively clear, but it is very different than in state court. You have an initial appearance, which is covered by Rule 5. Hopefully, that initial appearance is one that you can pre-schedule, agree on a time with the prosecutor, and agree to walk in with your client and have the bond agree to as well. And they can be out. They don't have to spend a night in jail if you can accomplish that. That whether they're willing to do that or not is one of the primary incentives to one of the incentives. I wouldn't say primary. One of the incentives to cooperate with the government in whatever way makes sense for your client is that they'll very often say, okay, if you cooperate, we'll agree to not only the voluntary surrender, no arrest, no complaint, but also agree to a reasonable bond as well. So what happens at the initial hearing, it's within 48 hours as opposed to 24. They don't do holidays or weekends either in federal court, which they do in state court, and that can become annoying. It's handled by a magistrate judge. He will advise the defendant of the charges against him or her, the maximum sentence. If there has been at least a complaint, if they're already there, they've been arrested, there should already be a complaint. If they've received a copy of it and have reviewed it, if your client is arrested and you get called while they're in jail, you usually don't get the complaint until that morning. Was a lot easier before the pandemic to then go to the courthouse and have an opportunity to sit down and review it with the client. But if they are just handed the complaint, obviously every one of our clients' intelligence levels is different, their reading capabilities, their literacy. So it's been an issue during the pandemic, whether they've had a chance to review it. If they haven't, then the judge will read the complaint. And that's like in state court when usually you say, well, waive reading. If they haven't reviewed it, then the judge will read the complaint. He will advise, the magistrate will advise your client or the defendant of his invocation rights, his rights to remain silent, his rights to counsel, and ask whether he already has private counsel, intends to hire private counsel, or needs counsel to be appointed to him because he's indigent, and then he'll do an indigency application, just like if you've practiced in state court or if you've ever been a public defender, which I was. Of course, you're entitled to representation under Gideon. If there's already a charging document, such as an indictment or an information, by the time we go in, and that's usually if we voluntarily surrender, that means there never was a complaint because there never was an arrest. So there already is a charging document that we've agreed to. We can either ask, or the magistrate can ask, to handle the arraignment at that time. We can plead not guilty always, even if you have an agreement with the prosecutor. I want to be very clear beforehand. You always still plead not guilty because it's not that agreement has not yet been entered into the record. So client could potentially change their mind if with consequences. If an indictment or information has already been filed, it can be entitled to a preliminary hearing under Rule 5.1. It's like an adversarial preliminary hearing in state court. If a client has been arrested on a complaint, then it's, I believe, within 14 to 21 days. I'm blanking now on Rule 5.1. But certainly within 21 days, you have to have a mini trial on whether there's probable cause for them to remain in custody. But preliminary hearings are not that common in private practice. Good practice note, something that's very different. If you're entering your appearance for a client, either at their first appearance or at arraignment, the judge will ask you whether you have filed a temporary or permanent appearance. Not really common in state court. Temporary means you're only there for the purposes of your only representation duties are the detention, bond, in terms of release, and that you're not the actual defense attorney who's going to be receiving the discovery, who's going to be arguing motions, filing motions, going to trial. Or if you enter into a a permanent appearance, that means that you're all the way through, but you should also notate on the filing and in court whether that includes any sort of appeal or post-conviction if there is one, because the judge will ask you it. I always like saying it first. It gives you a lot of credibility, especially when you're new to federal court, because the judge will ask. So you can say, Judge, I've entered for permanent appearance, and the permanent appearance is to trial only. Doesn't mean you're going to trial. It just means that you're not doing any appellate work on the case, or you haven't been retained to yet. So the bail process is somewhat similar, but also somewhat different, and it can be often more favorable than in state court. The government can move for detention at the initial appearance. You should definitely, or you have to, be very familiar with 18 USC 3141 and certain kinds of cases, depending on the nature of the charge, which is laid out here. That's under 3142F under 18 USC. The government can automatically ask to detain your client for 3 days to prepare for a bail hearing. So it doesn't always happen like in state court at the initial appearance. It's more like a bond motion in state court, I guess, but it happens quicker probably than a bond motion, because depending on what district you're in. Case that involves violence, maximum sentence of life, minimum mandatory sentence of 10 years by the Controlled Substances Act, which is a lot of drug trafficking, or if any felony if the person has been convicted of 2 or more. Those are cases where they can ask for your client to be held an additional 3 days without a bond to prepare for a motion. And the motion is essentially those they get 3 days for. They can also ask for a motion or a bond hearing to be set even if your client is released. They can still file the motion to have pretrial detention. Not as common in all state courts, in all counties, like where I am in Broward County in South Florida. It's common in Palm Beach County. It's never really a thing. But in federal, they can do that if there is a serious flight risk, or if your client is a danger to the community, similar to state court. The defense can ask for up to 5 days to prepare for that bail hearing or that detention hearing, if we so choose. So types of bond are a little bit different in federal court, and you want to be really up on them. You have personal surety bond, which is not a thing in state court. 10% bond is very similar. It's similar to state court process of using a bail bondsman, but with no bondsman, 10% paid directly to the clerk. Corporate surety bond is a bail bondsman is required, and in federal they take 15%, and the entire amount of the bond has to be collateralized with assets, usually a home. Personal surety bond is where in the best case scenario, if you can negotiate for it, you can negotiate that client just has to sign a paper saying that he'll be responsible for $100,000 bond if he violates, but he doesn't actually have to put up any money. Sometimes the court will, or often the court will require co-signers. Sometimes family members are acceptable, or other people who will co-sign. And if there's a co-signer, the court will usually need to determine that that co-signer has property that a lien can be placed on if there is a violation of the bond terms. But personal surety is the best option. There can also be different kinds of conditions that are put, like in state court. There can be mandatory substance abuse testing, drug evaluation, house arrest, home detention, and different forms of that with an ankle monitor, sometimes with a GPS monitor, sometimes with a more of just a curfew geofence monitor. You could be released on a personal recognizance, but it's really never without conditions. So sometimes personal surety is just better if your client intends to stay. And so just go ahead, read 3142, 18 USC 3142, clear as day. But you want to know it really, really well. Practice tip: try and get a personal surety bond. Most important difference with federal is because you can negotiate bond, you might already be in a 3-month long process of negotiating terms with the prosecutor, charges and bonds. And if you're going to negotiate a bond with them and be willing to a charge or be willing to cooperate and cooperation is going well, fight really hard. Always fight really hard, but fight really hard to make them give you a easy bond, because of course that's one of the most important considerations of any of our clients is their freedom and their ability to get out. Have a cosigner ready to go beforehand. Don't wait until the last day. Have a bondsman ready who's prepared to accept the bond, and make sure it's a bondsman that works in federal court and has connections with the U.S. Marshals. Be prepared in advance. If you need a bondsman, call me. Be prepared in advance for possible nebia. Nebia is also a state court concept. It's very common in federal cases, especially ones involving financial crime and drug crimes, narcotics crimes, basically saying that the court has to be confident that whatever collateral or whatever money is being used, put up as collateral, or whatever money is paid as a bond, has not been unlawfully obtained. Otherwise, there's going to be a nebia hold. If you do get to a bail hearing, call witnesses, members of the community, family, friends, put on a full bond hearing to show why they're not a danger to the community. Also, it's really important to know the standards of proof, because these are pretty nuanced in federal. In a pretrial detention hearing, which is brought by the government, it's actually the government's burden to establish by clear and convincing evidence that no conditions of release will reasonably assure the safety of the community. That's usually reserved for the most violent crimes or sexual crimes, but not even so much sexual. Well, that's violent as well, but murders and robbery, things along those lines. Standard is different when the issue is whether any condition of release will reasonably assure the defendant's attendance at trial. That's the risk of flight aspect, not the danger of the community. Then the standard is not clear and convincing evidence. It's preponderance of the evidence, and they get to choose which one. So they could just go on flight risk. That happens if your client often is a foreign national, but in response, we will stipulate to waive extradition and surrender a passport, and that helps. But they can go on either one. But the standard is the burden of proof is on the government.